Okay, good afternoon, and welcome to this year's Inventing America Conference, 250 Years of Patent-Powered Progress. My name is Brian Pomper, and I serve as the Executive Director of the Innovation Alliance, one of the hosts of this conference. I would like to thank our co-hosts, and it's a list here, so bear with me, the Association of American Universities, the Association of Public and Land-Grant Universities, AUTM, the Medical Device Manufacturers Association, the Alliance of U.S. Startups and Inventors for Jobs, the Licensing Executive Society, USA and Canada, and Save the American Inventor. So thank them all for having this conference here today. Thank you. The title of our conference this year is, of course, a reference to our nation's 250th birthday, which we'll celebrate in just less than 2 months from now. It's a good moment to reflect on some of the conscious choices our founders made in the first Patent Act in 1790 to create a patent system in the United States different from the British model they had inherited. First, they moved from a system of royal privileges where only the rich and connected could get patent rights to one based on legal rights grounded in statute that could be secured by ordinary citizens who met the statutory criteria. Second, they made clear that the purpose of a patent was not to grant a monopoly to reward political allies, but, quote, to promote the progress of science and useful arts, to quote the Constitution. For that reason, patents were made available only for new and useful inventions. Third, they created an objective, merit-based examination system by establishing a board that would determine whether an application for a patent satisfied the new statutory criteria. Finally, they made the patent application process straightforward and relatively inexpensive so that you didn't already have to be rich to apply for a patent. Their hope in making these changes was to create a patent system that would jumpstart innovation and stimulate widespread economic development. Do you think it worked? Sure seems to me that it did, and that's what we're here today to celebrate. We'll first hear from Hank Johnson, currently the ranking member of the House Judiciary IP Subcommittee. But if the political winds continue to blow in the direction they seem to be blowing, his title may change to chairman. We'll then convene our first panel, which will explore the second Trump administration's patent policy. While there is much that divides Democrats and Republicans in Washington these days, this Democrat, at least, is delighted with what he has seen from the Trump administration on patent policy. Our second panel will dive more deeply into how patents make America stronger to remind us why what the Trump administration is doing on patents is so important. And finally, we'll hear from one of the architects of the Trump administration's patent policy, Deputy Director Koch is up to and how they are achieving their goals. Following the formal program, I hope you will join me for a drink or two during the Inventing America sponsored happy hour in the lobby. And just a programming note, our panelists will be happy to take questions from the audience if there are any. Thank you for your attending and for caring about the U.S. patent system. I look forward to grabbing a drink with you after the conference. Let me invite up Matt Szczepanka to introduce Ranking Member Johnson. Is he here? Oh, there you go.
Thank you, Brian, and good afternoon and welcome, everyone. My name is Matt Szczepanka. I'm of counsel here at Covington in our Public Policy Practice Group. As we celebrate 250 years of U.S. patents, it's appropriate that our next speaker plays a central role in ensuring the U.S. patent system continues to drive American innovation for the next 250 years. Congressman Hank Johnson of Georgia serves as ranking member of the House Judiciary Committee Subcommittee on Courts, Intellectual Property, Artificial Intelligence, and the Internet, which are, I think, pretty uncomplicated, straightforward subjects, Congressman, where he's led the Democrats as chair or ranking member of the subcommittee since 2019. And as Brian mentioned, hopefully we'll see him take the gavel back as chairman in 2027 if the Democrats really take the House. Now in his 10th term representing Georgia's 4th Congressional District, Congressman Johnson worked as a criminal defense lawyer and magistrate judge before his election to the House. As this group knows well, the IP subcommittee has jurisdiction over all U.S. patent, copyright, and trademark law, and has oversight of the U.S. Patent and Trademark Office. In his role as chair or ranking member, Congressman Johnson has long championed access to justice for American inventors and small businesses and supported key bills to promote diversity and equity in the patent system. He is a co-sponsor of the Restore Patent Rights Act to restore meaningful injunctive relief for patent infringement, and has called on Congress to take up PTAB reform legislation to codify changes proposed by the USPTO that protect inventors and patent holders from repetitive administrative challenges to their patents. For his commitment to strong IP rights, Congressman Johnson earned an A grade on the Council for Innovation Promotion's 2025 and 2026 Congressional Innovation Scorecards. And in 2023, the Innovation Alliance honored him with its 2023 Champion of the Inventor Award alongside North Carolina Senator Thom Tillis. Congressman Johnson, thank you for being here and for your work on behalf of inventors and patent holders in Georgia and across the United States. And now please join me in welcoming Congressman Hank Johnson.
Thank you, Matt. And thank you all for being here today and inviting me to speak to you. Patent and innovation policy is often viewed by people not in the business of inventing as an esoteric area of the law, meant more for corporations than everyday people like you and I. But America's founders meant for patents to be for the people, not giants. They believed that by rewarding any individual who can meet the standard for a patent, all of us would thrive. But reputations like patents, sports of kings, can be difficult to overcome. And it's been made worse by 2 decades of system change that have made it harder to own and enforce a patent. I'm here today to say that it's time to make the patent system work for the people again. One of the reasons America's economy became the envy of the world is not just because we have smart people here. It's because we have a system to allow those people to make a living by coming up with new and better ideas. Innovators with the confidence to invest in themselves know that a novel idea can change not just the world, but the course of one's own life. But it's not always so easy. Anyone who works with inventors and innovators can tell you that unpredictability is the hallmark of innovation. Patents are granted to creations that are, among a few other requirements, new. To invent, we need to do something that has never been done before. Individuals need the resources, investment, and most of all, the promise that if they are able to discover something new, they can own their idea without someone stealing it. Yes, nothing is stopping inventors from getting to work inventing, but to make those innovations and discoveries worth the time, energy, and money needed to obtain a patent, the resulting patent needs to be more than just a piece of paper that you hang on the wall. A patent should be reliable enough for an inventor to be able to convince investors to help transform the idea into a reality, from paper to product on the shelf. 2 decades of changes that included multiple Supreme Court decisions, landscape shifting statutory amendments, and technology evolving faster than most experts can keep up with, have made for opaque rules governing enforcement of patent rights. Even once an innovator owns their patent, it can be difficult to know that it won't be taken away if and when a big fish decides to infringe upon it. That is why I'm proud to co-sponsor the Restore Act, which would bring preliminary injunctions back to patent litigation. It's not the only fix we need, and certainly not the largest, but It is a positive step in the right direction. But innovation isn't just about enforcement. The strength of the patent office affects the strength of individual inventors' patents too. Let me explain. Under the Trump administration, the patent office's workplace morale has plummeted, likely because of the administration's layoffs, which were bizarrely characterized as an attempt to save money, even though the USPTO is self-funded. USPTO employees' collective bargaining rights were done away with in a very king-like way, destabilizing the already fragile workforce. And the USPTO has limited the number of hours that examiners can be compensated for working on an application. If these changes sound to you like internal strife unrelated to patent law, you should look closer. Patent examiners, employees who work on international innovation issues, and coordinators who do outreach to underserved communities directly affect the strength of patents granted. The enforceability of those patents overseas is also impacted, and the pool of innovators working on the next big idea is also impacted. This lost mission is most obvious in the USPTO's cancellation of its planned Southeast Regional Outreach Office in Atlanta, Georgia. The USPTO chose Atlanta after a long process as prescribed under the law. And instead of going forward, the Trump administration, in a very kingly way, canceled this outreach to the Silicon Valley of the South and instead opened it with the USPTO headquarters already in Alexandria, Virginia. Yes, this contract was near and dear to my heart, but it also would have served an innovation hub in the United States to foster more individual inventors, decentralized from Washington, D.C. and the president. American innovation can thrive only when the opportunity to participate is accessible to all. By placing the Southeast office at USPTO headquarters just outside of DC, the USPTO has limited its reach and concentrated opportunity among those already best positioned to access it. As you can see, I strongly disagree with the Trump administration, and I dislike what they've done to the USPTO in those ways. But I acknowledge the effort by Director Squires, which has made reform of the Patent Trial and Appeals Board, which reflects my ideas that the subcommittee has examined when I was chair, and which has similarities to those proposed in my colleague Congresswoman Ross's Prevail Act. Even then, while these administrative changes are certainly worth discussion, agency action is not the same as legislation. When the director changes, so can interagency rules. Patents exist to ensure that research and development rest on firm, predictable ground. This kind of vacillation between presidential administrations undermines the stability that is essential to a functioning patent system. Ultimately, these are questions for Congress to decide, not the agency. And they are questions I look forward to addressing if I become chairman of the subcommittee in the next Congress. A healthy USPTO requires clear rules, consistent leadership free from political influence, and a steadfast commitment to protecting those who take the risk to create. It is incumbent upon us to get these questions right, because inventors and job creators are not asking for favors. They are asking for a predictable and stable system they can rely on. When policy shifts with the political whims of an administration, It is the individuals in the American innovation system who pay the price. I applaud everyone in this room for their commitment to creating a patent system that works for everyone. And I welcome your questions. Thank you. Sure, Matt.
Coming.
Hi, Congressman Hank Johnson. My name is Nisha. I'm a reporter with IAM. My question is, what is your opinion on what the Patent Office should do to improve the morale of the Patent Examining Corps?
Well, I think they should immediately reinstate the collective bargaining agreement that was in place so that workplace conditions can be improved. I think the administration needs to listen to the workers on the ground, consider them partners as opposed to underlings who are disposable. These are highly trained, top cream of the crop individuals who take a pay cut when they come work for government. They could be working elsewhere, making much more money and under more hospitable conditions. And so when we start making their life so difficult by imposing hard to meet or sometimes impossible to meet standards, it erodes their quality of life, but it affects the quality of the patents that get issued as well. And that undermines the ability of creators, innovators, inventors to have the kind of certainty that they need when it comes to the enforceability of their patents. And so, you know, it starts with the workers who are issuing the patents. And so we need to make conditions better for them to be able to do their job. And we need to hire more. And that making the job more attractive is very important. We need more patent examiners, and we need to make the ability to obtain patents easier. And so we need more, not less, district offices around the country.
Congressman Bill Wichterman, I'm here at Covington. Thank you so much for your comments, spot on, about the importance of patents to our country. And as you know, there's a lot of bipartisan support for three very strongly pro-patent bills, the Prevail Act, the PARA, Patent Eligibility Restoration Act, and also the Restore Act regarding injunctions. Can you say something about what you anticipate if you're chairman of the IP subcommittee about moving those bills in the next Congress?
As I used to say as a lawyer, but their time on the House floor, in committee and onto the House floor, they have been well publicized, talked about, debated, and it's time for action. Needs to rise priority in terms of whatever caucus is in charge. Those three bills need to make their way to the top. And so we'll need the assistance of all of you all in the room to make policymakers understand how important movement is to bring our patent system to a point where it is again working efficiently and effectively to produce and protect patents and ideas, new ideas. I mean, new ideas are coming along, and we have to have those ideas need to be patentable. standards in terms of patent eligibility, just crying out for attention. We can't afford to wait much longer before we lose our competitive edge as a nation in terms of innovation.
Congressman Johnson, thank you for your remarks, and it's good to hear that you have a vision that sounds very similar to what I understand the system to be. So my question is, the innovation cycle that you mentioned, where people can get a patent, commercialize it, attract investment, defend it. How well do you feel that your other congressmen understand that cycle and its importance, and what could be done to help give them the focus that you seem to have? If I could.
Yeah, I can't really speak to to how well other Congress people understand patents and the importance that they are to our nation. I mean, most folks know that our Constitution talks about patents, and but most people we just use the products that are patented, and we want them to work, and we want them on demand, and as long as they're there, we are comfortable, and we may not even know what we don't have available because of a patent system. We don't want it to get to that point. But so it's up to the committees and the leaders to put forward legislation that addresses what's best for the common good. And I think most Congress people, I'm not familiar with everything that takes place in even my own committees, much less some of the other committees. But I depend on my colleagues and their expertise, and I think others do the same thing. And of course, stakeholders are important in terms of being able to talk to committee members or to Congress people and their staffs. And I think you'll find people are receptive to broad ideas, like if you explain things to people in a way that they can understand. They may not know what a biosimilar is, but they do know that they do understand how important it is for a person to get injunctive relief if their invention or if their product is infringed upon. They know how important it is to be able to stop the infringement if you can show that your product, your baby, is being stolen. They understand that, so we can get people to understand. I don't think that's a big issue. But the number of issues to save our democracy are piling up. And it gets to, when you consider the number of legislative days in a year and the number of issues and how long it takes to deal with those issues. And, I mean, stuff keeps piling up, and so we keep putting stuff to the back. So it's going to be up to us to, despite how much gets in the way, we're going to have to press forward, be real aggressive about making sure that people understand that America's stature for innovation is at risk. It's going to hurt our economy if we don't take care of the business we need to take care of in terms of protecting people's property, intellectual property.
Hello, Congressman Johnson. My question is, I'd like to hear your views on the cost of patenting. I think that there is an argument that the costs of patenting through both the legal side and the USPTO side can be a barrier, particularly for independent inventors and those of lesser means. What are your thoughts about the costs of patenting?
Well, I think the inter partes review process was a great concept. I think that it needs to be tinkered with, make sure that it does not promote the same inefficiency that it was put in place to get rid of. And so, things like I mean, if we have an 80% rate of overturning patents, something is wrong somewhere, either with the patent process, the patent issuance process, or the PTAB process, or both. But we've got to make sure that we bring finality and that we have a rule of law standard, as opposed to arbitrary decisions from on high that affect people who make the decisions on whether or not to sustain a patent or not. We need to remove those kinds of barriers. We need to put in place mechanisms that avoid duplicative proceedings. So you should not be able to, bring multiple actions against the same inventor or the same patent owner to the same tribunal. I mean, once the issue has been resolved, it should not have to be resolved at that level again. In terms of, the litigation process, that's going to talk with the $2,000 an hour crowd who run things up for perhaps those who are wealthy enough to pay them, and maybe they will decide that what they're doing is not creating efficiencies for the process overall, but I don't think that's going to happen. So you're going to deal with high-priced law firms and wealthy accused infringers who can afford to string out a process or abuse a process. But if you have laws in there to create the certainty and to prevent duplication, I think you can go a long way to protecting the less powerful from the powerful.
Yeah, thank you. I was struck by your comment about the role of intellectual property in relation to the public good and common good. I was just offering you, a moment to expand upon that. We hear a lot of arguments these days that, pharmaceutical patents, for example, are not in the common good, that patients don't get access to medicines. We hear a lot of arguments that intellectual property is getting in the way of it. So, if you could expound a little more. I mean, I tend to agree with you, but I'm just curious your viewpoint on that connection.
Yeah, I think that there are people working in companies. Sometimes they're working in maybe out of their basement, or maybe in a small office somewhere, and they are coming up with new, novel solutions to health issues. They are extending known substances or morphing into new substances that deal with other prior undiscovered efficacious uses. And so people are looking for a edge so that they can create something new and monetize it and make a lot of money for themselves. But they are acting for the common good when it comes to what the products that they are bringing from idea to the shelf. They are actually helping people live longer, healthier lives, curing illness, preventing disease. I mean, that's good for mankind. That's the common good. And so it doesn't have to be just with biological or chemical products. It can be with I mean, Wi-Fi, great for the common good. I mean, everything that you know, quantum computing, you know, great potential. Don't ask me what it will do, other than make things, speed things up. But we'll find a way to make human life better, and unless we destroy ourselves in the process. I mean, we can create we can create things that are not in the common good, but I mean, they said that about nuclear weapons, but now you get clean energy from nuclear reactors. You know, so yeah, so it's we need to strive as we move forward with new ideas to make sure that we're promoting the common good. We always should have the common good in mind, I think, not just what's in it for me, but how can this help the common good? And I think that's what most people who are inventing are doing. I don't think there's many mad scientists out there trying to find a way to destroy humanity, destroy the planet, and you know, and the entire unfathomably vast universe. I don't think there's anybody out there trying to destroy life. I hope not, anyway.
All right. Thank you, Mr. Johnson. Can I invite up the first panel that will start now?
Okay, thank you everyone for being here today. It's a pleasure to be here on the stage with you. I'm going to moderate this panel. My name is Gene Quinn. I'm the CEO and founder of IP Watchdog. And thank you to Covington for hosting this, and Brian specifically for the invitation. Greatly appreciated. And thank you all for being here today. Let me briefly introduce our panelists. You probably all know these guys. They don't need really any introduction, but we'll begin with Walter Koeppen. Walt is a former Undersecretary of Commerce for standards and technology. And now he is the impresario of innovation at the Colorado School for Mines. So thanks for being here, Walt. Next to Walt is John Dubiansky, and John is Senior Director of Intellectual Property Standards at Dolby Laboratories. And to my left is Austin Mayron, and Austin is a senior legal advisor. He's pinch hitting for Nick Matich, who was arguing a case down in Texas today. Thanks for being here, Austin.
Of course.
And then last but certainly not least is Peter Anthony Pappas, who's the Director of Intellectual Property Policy on the Senate Judiciary Committee working under Senator Tillis. So gentlemen, thank you all for being here. The topic that we have for our conversation here today is patent policy in the second Trump administration. So we can really talk about pretty much anything we want to talk about, I suppose, because Trump and his team are really touching it all. Walt, I'll start with you. Let's just see the conversation, if you will. What do you want people to have in mind from your perspective as being something that's worthy of our conversation about what's going on in Trump 2.0?
Thank you so much, Gene, and thanks to Covington. Thank you for the opportunity to join with you in this important conversation. We're at a time where we're seeing positive momentum on a bipartisan basis for intellectual property rights, for greater clarity. During the comments that Congressman Johnson just shared, we have a series of bills before Congress that are very promising indeed. And we have an opportunity to move forward for greater clarity, for greater enforceability and greater efficiency as we also think about the patent process, as we think about inter partes reviews and the functioning of the PTO and the PTAB. We are seeing a time also of great risk for the United States. And within this past couple of years, China has overtaken the United States with respect to intellectual property filings, international patent families in key areas that are critical to global competitiveness and to national security. Fields including artificial intelligence, including quantum science and engineering. And so for the United States to restore its ability to secure the innovation capacity that we need for the future is absolutely essential. We're also at a time where we have opportunities to move forward on this whole field of technology transfer and commercialization from our academic institutions, from our research institutions, the importance of the Bayh-Dole Act and some of the reforms that have been instituted over the past couple of years have been really important, and it's great to see the support of this administration for those changes. But there's more to be done. The Stevenson-Weidler Act that governs technology commercialization from the federal sector and how federal entities partner with the private sector and other nonprofits remains unaddressed. And so great progress. I was thrilled to see the 301 report that came out of a USTR recently with and I think an important series of statements from this administration about the enforceability of intellectual property rights and their importance for global trade. So progress, lots to be done.
Okay, great. Thanks, Walt. John, your opening remarks.
Well, first of all, I'd also like to thank the organizers for inviting me to speak on, I think, this very important set of issues. And in many ways, I want to echo the remarks that Walt has given. I think we are moving in the second Trump administration towards a increased and further recognition of the importance of intellectual property rights, perhaps a recognition that in times past, the pendulum has swung too far in the direction of skepticism towards IP rights, and there is a need to not only recenter the pendulum, but also to really recognize the importance for the need of strong IP rights. And I think there's a broader recognition across the administration of the importance of IP in fostering innovation and of the importance of innovation to furthering national aims, certainly in national competitiveness, as well as in the development of key critical technology sectors. I think there's a broadening recognition that IP is not something that's handled in the abstract, but is rather a part of a much more important federal policy when it comes to these issues. You know, one of the threads that I've really enjoyed seeing coming from the competition agencies in the US, the DOJ and the FTC, and some leadership there, is a recognition that innovation is best served when innovations can come from a variety of sources in the marketplace, from large companies, small companies, lone inventors, research institutions, and that irrespective of where the innovations are contemplated, they're able to find a path to market, and that IP is a critical enabler of doing so. And I think that that view has informed policy, both from certainly the Patent Office, some of the things they're doing, the views that are echoed in joint statements with the DOJ, and also in the USTR and in the international context in its recent Special 301 report.
Great, thanks, John. Austin, your initial thoughts.
Absolutely, and thank you to our hosts for having us today. I'll start with my remarks with something that Deputy Director Stewart often opens her remarks with, and because we're talking about intellectual property, I want to assure you that I have a license to use these remarks.
So you're not stealing this?
Correct. It's a royalty-free license. But this is a really unique administration when it comes to intellectual property rights. At the top of the administration, we have the president, who is one of the most prolific brand owners on the planet. He's put his name on everything from golf courses to vineyards. He understands the value of a trademark and of a brand. Our vice president, J.D. Vance, he has an award-winning memoir that was turned into a movie. He understands copyright. He understands the importance of being able to tell your story and having enforceable rights in it and being able to monetize it and bring it to all of our homes through streaming on Netflix or however any of you saw the famous Hillbilly Elegy movie. Then we have the Secretary of Commerce, Secretary Howard Lutnick, who is a prolific inventor with over 500 patents in his own name. He fundamentally understands the inventive process, the importance of patents. His companies relied on them, and he understands how important the patent system is to the economic competitiveness of the U.S. And then when you add to that trio, you add our director, John Squires, who has decades of private sector experience from Wall Street to law firms doing litigation, and our deputy director, who herself has decades of experience, including at the U.S. Patent and Trademark Office. We just have an incredibly stacked group of individuals who understand and emphasize the importance of intellectual property. So it's been terrific as a younger member of the administration to get to see these visionaries and leaders set intellectual property policy. And when we came in 2025, the patent system was, I would say, in crisis. It really was struggling. There was an uptick in the unexamined inventory. The unexamined inventory ultimately ended up peaking at 830,000 applications. And if you go back and you look at the news coverage and what people were saying at the time, there were prominent thinkers saying, do we need patents anymore? Is the patent system working? If you have to wait 3, 4, 5, 6 years to get a patent, does the system actually work? On the other end of the spectrum, when it comes to issued patents, there was a lot of destabilization and distrust. There was incredibly high rates of patent invalidation claim cancellation at the PTAB. There was serial litigation, serial patent challenges. One example that sticks out in my mind from those early days is a case where a particular patent had been challenged 6 or 7 times and had gone all the way through a jury trial that had gone up to the federal circuit, affirmed, and then the agency came out the other way. And that's an important policy question. Is that the business the USPTO should be in? And so for the first year and a half, the administration has been taking emergency steps to stabilize the system, to restore confidence, to convince the entire ecosystem that patents are something worth having. They're good for the economy. They're good for inventors. They're good for the public. And now it's very exciting as we dig into more fully into year 2 about how we can continue to refine and improve the system.
very near and dear to your heart, as is Bayh-Dole, and I see them sort of on one continuation. When we got it right with Bayh-Dole, and we could certainly get it right with the federal labs and so forth. And I know when you were director of NIST and Secretary Ross was at Commerce, there was a real push there.
Yeah.
Where do we stand with that at the moment? And do you think it's starting to resonate in a way? And actually, maybe what we should do is I should also ask you, take a step back. For those who aren't in the weeds on that particular issue, what's the nut there for the takeaway message?
Thanks for queuing that up, Gene. So Stevenson-Weiler Act is the companion legislation to the Bayh-Dole Act that really enables technology partnerships, technology transfer from federal agencies into commercial practice. It also governs the way partnership agreements between public and private sector entities work when they're federal partners engaged. The issue that came out of what we call the Return on Investment Initiative that ultimately led to a legislative proposal that went to the House and the Senate called the Return on Investment Proposal incorporated a number of changes. Number one is to create greater degrees of freedom of public and private partnership, enabling much more broadly the creation of foundations for the federal entities and the federal mission. And we have some that have been deployed, for example, within the Department of Energy system. There's a foundation for the National Institutes of Health that's been an important contributor, but there's more to be done. And rather than trying to deal with federal conflict of interest rules, which was going to be a very long journey, having a workaround process and also enabling other transaction authority to be more broadly deployed would enable a lot more flexibility in public-private partnership and in particular with the federal sector. The other challenge that we've seen, and this deals more with copyright law, is that there's a requirement for digital products and otherwise copyrightable works to be made freely available, and that includes quantum software and other executable code that currently under federal statute would be made broadly available to everyone, including to our global competitors. And so enabling federal agencies to retain copyright around digital works and around executable code, in particular in areas that are important to the U.S. economy, were all part of these provisions in the return on investment legislation proposed to update Stevenson-Weiler. There's a lot to be done. And I think just as we were talking about with these important pieces of legislation, the changes that are called for in Prevail, in PARA and Restore, the ROI initiative legislation is another piece that really can use momentum at this time. And Gene, you reminded me in a recent conversation that the Bayh-Dole Act actually was brought across the goal line at the very, very tail end of administration. Birch Bayh was lame duck, he was on his way out, but he and Bob Dole really persisted in seeing this legislation ultimately across the goal line. So if there's a challenge maybe for Thom Tillis, it's looking upon these periods of transition as a real opportunity for the nation. And Peter Anthony, thanks for your efforts. Thanks for your call to action here from this group. And it's, I think, just really an important time for us to maintain momentum during this period in this administration to move this important set of legislation across the goal line.
Great, great. I want to follow up. I want to give the audience just a little bit of context though, and then wrap this up with a question about the federal labs. But before Bayh-Dole was enacted, let's recall that you could, if you wanted to, license technology from universities. Just nobody did. because it was an extraordinarily Byzantine process. And when I say nobody did, it was zero. There was zero. And the starkest example I can provide is before Bayh-Dole, we all know today that universities play a critical role in drug development. Before Bayh-Dole, they did not. There was zero drugs developed by universities ever made it to market. And since Bayh-Dole, we're at now 160, 170 drugs over the last 45 years have gone from university lab to patients. And we're talking about heart disease, cancer treatment, some of the, the things that have kept us and loved ones alive. So the question on the federal labs issue is it as stark there? Because the labs are every bit as innovative, maybe even more so, because they dream big. Is it that stark on the federal labs as it was with the universities?
It's not quite as stark, but it's pretty close, Gene.
Yeah.
And I think that there are huge opportunities. The federal labs, according to the statistics that come out from the Federal Laboratory Consortium, published on a regular basis, NIST issues annual reports. They're dramatic underperformers. And a fundamental reason is the Byzantine world that they're still stuck in. And so creating these greater degrees of freedom, creating new pathways of partnership and enabling technology commercialization, licensing from what represents currently over 1/3 of the federal investment in science and technology in this nation goes through the federal laboratory system. So there's a lot of investment returns that should be available to the American people from intellectual properties that are either not being protected. Some of them are only being protected in the United States. And so the role of intellectual property, the role of patents, of course, is to teach. And therefore, the federal system is teaching our global competitors without protecting on a global level. So there's a lot to be done there, and the time is.
And when was the Stevens-Weiler Act is pretty old?
It's companion to Bayh-Dole. It came out in 1980.
And it has not been updated.
It has not been updated substantially.
And it's one thing
since 1983.
Bayh-Dole probably doesn't need to be updated because it's been an extraordinary success. We need to defend that. But it's like, yeah. But then you compare what's going on in the federal labs. And I remember the event you had at the Institute of Peace. It was a wonderful event back, and Secretary Ross was there. And he was like, paraphrasing, he's like, I maybe don't necessarily understand the science here, but I understand the business. And when you tell me that we could have this or we could have zero, I think having this is what we ought to try and get to, right? So hopefully we'll get that over the hump. But
thank you, Gene. And I think it's really up to the knowledgeable people in this group who are looking at the future of intellectual property and the future of intellectual property commerce for the benefit of the United States in a time where the competitive landscape has shifted in China's favor. And I mentioned some of the technology areas, but there are a number of very clear studies that have demonstrated the United States is now at a strategic disadvantage relative to China. So recovering patentability and looking at return on investment from federal science and technology, as well as more value to be created from the broader S&T investment in the United States is necessary.
Great. So John, I don't want to pigeonhole any of your comments here because standards is a big area, but it is an international area. And the U.S. companies, and I just respect the hell out of Dolby, being an audiophile electrical engineer, I just, I get chills when I think of the innovation that you guys have created. But SEPs have become almost, I wouldn't call it a shell game. That's what pops into my head where, you have this jurisdiction, that jurisdiction, and you're just constantly moving the pieces around. But from your perspective, how are things going in the U.S., particularly like say, since we were talking about President Trump over the Trump term, like the 5 or 6 years he's been in office and where we expect things to go. And how does that compare or contrast to what you see elsewhere around the world?
Well, thank you, Gene, and I'm really glad to see you're a fan of our technologies.
I really am. I'm a nerd.
But I would like to take a quick step back, just regarding standards in particular, the standardization ecosystem has just driven innovation across verticals for decades already. And in the case of audio and video, where Dolby's been fortunate to participate, we have seen a real evolution, really going from the first analog TV to HD TV, and now moving from that to stereo and surround sound and the like. And it's all been really fueled by this ecosystem. For many years, going back, I'd say to probably the late Bush years, standard essential patents, when the government took an interest in the U.S. or really elsewhere around the world, it often began with antitrust agencies coming in almost after the fact and raising concerns that the process was abused or that the owner of the standard essential patent was abusing the rights that they had. What we started to see, really going back, I think into 2022, 2023, was a recognition by governments that you can't just look at what's happening with standard essential patents and take for granted that they're going to be developed. But that instead, it's very important to focus on incentivizing participation by American inventors and innovators in the standard setting process.
Yeah.
And that there's a huge national imperative in critical and emerging technologies in 23 and moving forward today to ensure that you're focusing on the front end, that you're creating adequate incentives for American companies and also not just incentives, but the ability for them to lead in standard setting organizations, and also to create incentives for them to contribute their valuable technology to the standard setting process. So of course, we had the National Standard Strategy for Critical and Emerging Technologies that was begun, I think, in 23 and is still being implemented to some extent. But even under the Trump II administration, you start to see things like the AI Action Plan or the communication on winning the 6G race that identify the imperative for ensuring that American companies can contribute their innovations and take a leadership role in standard setting. I think that is the framework that this administration is operating under. And I think it's a great framework to be thinking about the process much more holistically. I don't want to steal the thunder of one of the co-chairs of the PTO SEP working group, who we're fortunate to have here. But one of the great developments that we saw from the private sector is that the PTO was adopting a lot of this perspective as well. Last December, they announced a SEP working group that had the goal, echoed a lot of these themes of, again, ensuring there's adequate incentives for American companies to participate in the standard setting process. And that this is coming from not just large companies, but small companies and the whole spectrum of innovators as well. And that's why I was very heartened to see that one of the first actions they undertook was actually the Spark program, which had a stated goal of helping small and medium enterprises that are focused on inventing, protect their IP that's relevant to standard setting. On top of that, of course, I think this administration is continuing to level set when it comes to things like remedies and also the antitrust claims against SEP owners, and ensuring that some of the more excessive skepticism of the past is being appropriately framed under the law.
Okay, great. So Austin, let me turn to you then, now that John has kind of teed this up. And I'm not trying to put you on the spot. And if this feels like it's on the spot, we could, talk about something. We could talk about the weather if we need to. But Nick, I think I know why Nick is not here. Nick Matich is currently the solicitor at the Patent Office, and he was arguing a case. And that case deals with remedies.
Correct.
And the Patent Office and this started with, I think, when Deputy Director Stewart was acting director, and has continued now with Director Squires there, has taken a position on behalf of the Patent Office to say that, hey, patents are property.
Mm-hmm.
And so I'll stop there and I'll let you fill in the gaps to the extent that you can. What do you want to tell the audience about what the Patent Office is doing with that in particular?
Yeah, absolutely. So when the new administration started, we looked around to see what could we do to improve the innovation ecosystem. And one of the areas where we could obviously work is legislation. And so we obviously know Peter Anthony and we know his team, and we are very interested in the legislation that's being worked on. We looked internally, in-house. What can we as the USPTO within the four walls of our building, what can we do to improve the ecosystem? And then we also looked to the courts and said, how can we engage in a dialogue with the courts to improve policy? And one of the areas we identified as potentially good potential for improving legal doctrine is on the availability of injunctive relief as a remedy. So in June of 2025, we partnered with the Department of Justice's Antitrust Division to file a statement of interest in a case called Radian, which involved seeking preliminary injunctive relief. We later again partnered with DOJ on a case called Collision, which dealt with a permanent injunction following judgment. And so, as Gene said, our solicitor, Nick Madish, is actually in Marshall, Texas, arguing today. I think he said the argument went for 2 hours and that it went very well. So I don't have a full debrief yet, but it supposedly went well. And then we also filed a statement of interest in a proceeding before the International Trade Commission. The ITC doesn't issue injunctions, but they do issue exclusion orders, which function similarly to an injunction. And the through line between all three filings is that patents are important rights, that sometimes remedies at law, monetary damages, are inadequate. And even under the Supreme Court's existing eBay framework, there are instances where injunctive relief is appropriate. And so we've taken the time in these filings to lay out various ways in which monetary damages may not be adequate. And so I was flipping through the briefs on my way over, and we talk about some ways in which monetary relief may not be adequate. I mean, just first, when you take a step back, and this is something that former Director Andre Iancu likes to talk about, fundamental to a patent is the right to exclude. And Andre loves to talk about, well, you own your house, and what if someone trespasses in your house and they say, I live in your guest room now, and you say, okay, I can't kick you out, but you have to pay me rent. That doesn't seem very consistent with the idea that you own the house, because now you have somebody who you don't want living in the house squatting there. And so they can say, hey, here's what the market rent is in your neighborhood. I get to move into your master bedroom, and I just get to live there as long as I pay you market rent. That seems sort of crazy. It's inconsistent with how we conceptualize rights to real property. And you see similar things in the patent context. For instance, a patent owner may want to license selectively. They may like a particular licensee and want to give them an exclusive license. Well, if someone comes in and they say, well, we want to practice the invention without a license, but don't worry, we'll pay you a royalty later. What if a patent owner wants to divide up a market geographically and they say, I'm going to have one licensee in the north and one in the south and one in the east and one in the west, and somebody comes along and says, that's a really nicely calibrated system you've developed. Doesn't work for me. I'm going to infringe your patent and I'll pay you a royalty. That seems very inconsistent with the right of a patent owner. And it applies to a whole host of other issues. For instance, a patent owner might reasonably insist on audit rights. They might say, we want to have visibility if we are going to license it under sort of duress from the court. We're going to give you a license, a royalty, but we want to have audit rights to make sure you're paying us the right royalty. Well, who decides what those audit rights are? Do the parties in a private sector arm's length negotiation decide what works for them? Or does a court sort of in a haphazard proceeding determine what audit rights the patent owner is entitled to? And so those are important questions within the existing eBay framework. And the office is trying to escalate them and elevate them with the court to hopefully find a positive resolution.
So I'm a fan of injunctions simply because I think that they, you can clap. That was very good. Because I think with eBay, what happened is you moved the resolution of patent disputes out of the boardroom and into the courtroom, because that's the only place an inventor has any chance, even, say almost like tongue in cheek, like you got a chance, I suppose, like it could freeze tonight, right? Kind of chance. But if there is a property right and it's strong and people have to come to arm's length negotiations in order to deal with that, I think that that's great. So even what struck me about what you said is that, the injunctions, you can't just pay for it. I think a lot of inventors, we're at the point where we've been so beat down. It's like, well, okay, I'll say no to the injunction if you're willing to pay me for it. But the problem, and these are really two of the same thing. Yeah. If I don't have an injunction threat, then how am I going to get you to pay for it? Because the people that are the biggest entities will just keep you strung out for 8, 10, 12 years or more and never pay you. Walt, you seem to be shaking your head. Yeah.
Absolutely. And so I've founded 5 companies and without having the ability to exclude, they would not have succeeded. I was sharing with some of our guests here a little bit earlier that I started my career at a company called Lubrizol Corporation, and there was a major patent litigation issue that was ultimately prosecuted on a global basis, but it started with a preliminary injunction here in the United States. It was the Lubrizol versus Exxon case. I spent a lot of time, in depositions and so on related to that, and so there's a lot of corporate waste that actually happens when you are forced into these litigation situations. But at the end of the day, without an injunction, you would not be able to get action. And so I think that the focus of the process right now to get the legislative changes in place and some of these approaches being taken now by DOJ, PTO, and others are most welcome so that U.S. inventors actually get an opportunity to have the right kind of deal.
Yeah. So Austin, I want to the extent that you can, without saying anything confidential or whatever, during this Trump term, I happen to know the belt is tightened at the PTO, and so the fact that the PTO is sending the solicitor to Texas to argue this case, I think is something that we all need to stop and recognize. Like that seems like, oh, of course, it's a case that matters and you would just do that. But a lot of things the belts have tightened to save people money in this Trump, whether it's good or bad, it's just it is, right? So what message does it send that Director Squires sent his solicitor to Texas?
Well, I think it's a very powerful message that the entire administration, president on down, the department and the director, they all view this as an important issue. This wasn't the USPTO alone. This was the USPTO in conjunction with DOJ, and USPTO sent a lawyer. DOJ also sent a lawyer. So it was 2 administration lawyers, and the lawyer that Director Squires chose to send was our solicitor, Nick, who's an incredible advocate for anyone who's had the fortune of watching him in action. So it really is a priority. We've now done 3 of these statements of interest. I expect in the future there will be more. And so it's an area where we're actively engaged. Folks, when they have interesting cases where the USPTO may be able to advance the ball, move policy forwards, we're constantly on the lookout for those types of cases. And I think going back to our earlier discussion, 2 quick points that I would add on, and these are points that we've been making in litigation, is the first is not to get too much in the weeds on patent law, but the eBay case came about because the idea was injunctions were almost automatic, and the Supreme Court came in, and what the Supreme Court said, they didn't say no injunctions in patent cases. They said no categorical rules on injunctions. And somehow over the years, no categorical rules on injunctions has become a categorical rule of no injunctions in patent cases, which is not what it's intended to be. And then the other aspect, I graduated from law school in 2018, and so I'm sort of late to the party. But when you talk about a singer who's going to perform at Madison Square Garden, and somebody sues them and says you have a unique service, and so we're entitled to an injunction to stop you performing in Boston the day before or something of the sort, there's sort of a market, and there's an understanding of what the person's services are worth. We've now had 20 years of what I would say is the systematic devaluation of patent rights because of the unavailability of injunctive relief. When you are looking at comparable licenses, which is what courts do, those are licenses that were negotiated without the threat of an injunction. Right. And so we are now here 20 years after eBay, and when we look to comparable licenses, the landscape is fundamentally skewed.
So what I'll say is recently we had an event at IP Watchdog, and we had John Lee was there, and he was speaking on a panel, and he said something, and I can't remember what he said, but I got in a little bit of a disagreement. I was in the audience. I got a little bit of a disagreement with him, and I said that innovation is just not happening. And he interrupted me, and he said, well, that's just not true. And it's not true. He was right to call me on that. So what I then said is what's not happening is the rinse and repeat innovation that we have historically been entitled to through the hard work of a lot of very creative people who then, if they come up with something that you all like, that you all want to buy, and it's got a good market value and that person can make money on it, then what do? They would go back and they would rinse and repeat and innovate again, protect and sell, and then that would keep going. And that's how, that may be exactly how Dolby started, right? I mean, with some real great technology, and companies like Dolby could not have existed in today's ecosystem, right? Because you can't build one ring at a time anymore. So it's the rinse and repeat innovation that's not happening. And how do we quantify what that means? You can't quantify something that didn't happen. Okay, so I don't know, and I think this is fundamentally the problem that we have trying to convey all of these things, but I'll just suffice it to say that I think in this administration, whether it's in partners in Congress, whether it's the PTO, whether it is the agencies like NIST, or whether it's the private sector, everybody's moving forward in a very positive direction. I have been very despondent a lot of the last number of years. And I'm trying not to get overly happy, because the hard work that a lot of people in this room have done has led us to this point. And it's always darkest before the dawn, and maybe we won't get anything done, but we very well may get something done at literally the last minute, like Senator Bayh was able to do in 1980. So we're now down to 0, but I think we have time for questions. Questions, right? Okay. So if anybody has any questions for any of the panelists, please, let's have more of a dialogue. I think we've got another about 15 minutes. So, and if you don't have questions, I can certainly ask more, but we would love to have you all ask questions if you have any. Okay, go ahead.
So sort of a question, but it's really to Walt. So my name is Phil Singerman. I'm with CSIS, but I was Walt's senior career wingman when he advanced the return on investment initiative. And what I would offer to this community is a very strong community here and at the universities. Mike Waring is here from Autumn, who can speak to that. But from the federal lab perspective, there's really no independent consortia interest group that could advocate for the kinds of changes in Stevenson-Weidler that are necessary. And Walt was a little modest. There's an enormous amount of intellectual property and potential patents that are stuck in the federal lab system. The plumbing is really clogged up. And what the Return on Investment Initiative did, pretty modest, but with great impact, is to clean up the plumbing so that the patents could flow out of the system more. So I would encourage this community to talk to Walt about what the strategy is moving forward. That's my question.
Yeah, no, and Walt, if you want to say anything, I think this is critical, right? If we saw what happened with Bayh-Dole and the delta between pre and when it started functioning, could we see that same delta again with the federal labs, you think, if it gets straight?
We can. I think there was the creation after Bayh-Dole of an entirely new technology transfer industry in the United States. And we've seen in the most recent years over 1,000 new companies per year that are created out of mostly federally funded research at our universities. The amount that actually comes out of the federal labs is minuscule. So there has to be, in addition to the legislative change, there actually has to be a cultural change. And so we can't underestimate the amount of time that culture change takes, but it is possible. And there are great models, and I think we as a nation have a great incentive to see more of our innovation capacity unleashed. So the return on investment legislative package is out there. It's available on the NIST website, and I'd encourage you to become familiar with that. And I think that with the moment that we are experiencing as a nation, I highlighted the changes with China's ascendancy. WIPO and WTO put out an annual innovation scorecard. The United States has dropped to number 3 in the most recent version. And part of that is due to some of these challenges that we still have in patentability, as well as restoring the vitality of our U.S. innovation system to be able to get more out.
Yeah, great, awesome. Any Arthur? Yeah, no, you're going the right direction.
Thanks. This follows quite closely on that. So universities have not just inventors who create the molecule or the technology that you can patent. They also have people or innovators who kind of can anticipate what markets will be, who would use this, and business students who want to start businesses. How do you get innovators to the national labs to like get to know the technology well enough to say, oh, here's how this could be used on the market, instead of, narrowly for national security, which might be what it was invented for in the first place?
Yeah, it's a great question. And it requires ecosystem building. And in so many ways, universities are part of that and can lead the way, because so many of the federal labs actually have academic partnerships that can actually open up access to entrepreneurs and the venture capital community, to provide insight and market research and the kind of risk-taking mindset that serial entrepreneurs can then build to that interface with the federal sector. So it does require a shift of these innovation ecosystems to create value. And I think in some ways too, in addition to these legislative changes, there are some agencies that have greater degrees of freedom. The federally funded research and development centers that are not operated by the feds, but are actually operated by contractors on behalf of their federal mission, do have access to additional tools, access to agreements for commercializing technology, ACT, that was originally pioneered by the Department of Energy. And so there are these mechanisms that are in place, but until we actually have a legislative change as well as a culture change, a lot of these technologies will remain still stuck on the shelves of the federal sector.
Hi, I'm Megan McEwen with the Association of Public and Land Grant Universities. Shifting the conversation to AI, there's a huge push in this administration to develop AI to lead globally. The Department of Energy has launched an ambitious effort called the Genesis Mission to accelerate the pace of scientific research, and you could say innovation broadly, using AI-enabled science. I'm curious, from your perspectives, do you foresee challenges with securing eligibility and patentability of these new AI-enabled inventions?
The short answer is yes. It's already starting to happen.
Yeah.
In ways where initially it did not, the office examiners did not seem to be treating AI like software, but the more familiar we're getting with it, the more they're treating it like it's software. And that's why I think the para is so critically important. Because para says right in it that if the innovation requires a computer, and with AI, it's going to require some kind of a computer, then it's eligible. And so I think that we have to get that across for national security purposes. We have to get para across the finish line. Austin, do you have anything to add?
Yeah, I was just going to say that's an issue that the office has been keenly looking at. In November of last year, maybe early December, Director Squires issued an opinion in a case called Ex parte Desjardins, which was inventors from Google DeepMind. And the patent in that case, the claims, they were directed to an improved model, improved method for training large language models so that a model could do more than one task without forgetting its performance on the other. And so Director Squires issued an opinion where he confirmed that AI can be an eligible subject matter. And also, as we sort of discussed earlier, there's a portion in there where the director said that we should really be focusing on 102, 103, and 112 as the traditional tools to limit patent scope.
The one thing I would, go ahead, Walt.
Well, I think this is one of the reasons also why on a global basis, China and Europe is marching ahead on AI related intellectual property filings, is just simply because we have shot ourselves in the foot through the actions of the courts. And to the points raised earlier, certain actions have basically restricted the United States then from actually pursuing the kinds of protections that are so important for our economy and for our companies going forward. And as we see more and more AI-enabled approaches across science and technology, and certainly the Genesis mission is a great example, we, as a nation, without these types of protections, then will wind up disadvantaged globally.
So we're going to need to end here, and I'll ask the next panel to start making their way up. And as you make your way up, I just like to throw this out there as a flag on this issue. I don't have any answers to this, but I know a lot of people are growingly concerned by the investment it takes in order to bring AI to the market. So if we do not have meaningful patent protection, what we're going to have is even more so a consolidation at the top with a very small few corporations that don't need patents. Let's just be on Google, Apple, not to single them out, but that type of company. They are so gigantic and so large, they don't need patents. They get patents, but they don't really need them. The people that need them are the ones doing the real risk-taking, came up with an idea, need to get investment to move it forward. And if we want a rising tide to lift this boat and become AI dominant like President Trump wants us to be, I think we need to leverage the best and brightest in the small universe, the individual universe, and not have a haves and a have-nots. So I don't have a solution there, but think about that, because I think it's going to become increasingly important. So, panel, thank you so much. Thank you. Walt, thank you. Thank you. Thanks, Jim.
All right, as folks are able, please find your way back to your seats and we'll begin our second panel. Good afternoon, my name is Morgan Shears and I'm a special counsel in the Public Policy Group here at Covington. Today, I have the pleasure of moderating our panel on how patents make America stronger. This year, as we celebrate the 250th birthday of this country, we also celebrate 250 years of patent-powered progress. Since our nation's founding, the ability to obtain patent protection has played a central role in promoting innovation, global technology leadership, and economic growth. As Brian Pomper mentioned during the introduction to this conference, the role of patents in making America stronger was even on the minds of our founders as they drafted the Constitution, which empowers Congress to promote the progress of the science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. From the light bulb to the internet, the genius of the American inventor has been supported by these constitutionally guaranteed patent rights. So there's really no better time than America 250 to pause and reflect on the law and policies that have shaped where we are today, and to look ahead toward the future we want to create for the next generation and beyond. I'm thrilled to join in conversation on this topic with Brendan McComas, who currently serves as Deputy Legal Advisor at the Department of State. In the prior Trump administration, Brendan served as Chief of Staff to then Director Andrei Iancu, and also served in the White House advising on matters related to trade, manufacturing, and IP. And Brendan has also practiced private patent law as well. On the other end, we have Lori Self, who serves as Senior Vice President in Counsel and Government Affairs at Qualcomm. In the middle, we have Dr. Elmisha Campbell, Vice President for Research and Economic Development at Jackson State University. Elmisha is also former board chair of Autumn and has more than a decade of experience in technology transfer and commercialization of university innovations. And last but certainly not least, we have Andy Toole, who is the former USPTO chief economist and will soon be joining Georgia Tech as an associate professor. So welcome to our panel. Andy, I actually wanted to start with you and really the big picture here. You're one of our nation's most prominent intellectual property and innovation economists, having previously served as the chief economist at the USPTO. What did the data tell us about the role of IP-intensive industries in boosting our economy and creating and supporting jobs? And what is the role of patents in promoting economic competitiveness and global leadership?
Right. Okay. Well, thank you very much, Morgan. And thank you to the organizers for inviting an economist. I don't know, I might be the only economist in the room. Other economists, raise your hands. Okay, it's true. Well, thank you. I think this is a great opportunity to talk about what the data are telling us. IP-intensive industries are a subgroup of U.S. industries that have above average holdings of patents, trademarks, other IP per 1,000 employees. That's what makes them intensive. So it's a cutoff kind of thing. But these industries are very diverse: leather manufacturing, electronics, drugs, colleges and universities. And so there's a very diverse set of industries that are part of the IP-intensive industries. And when I was at the USPTO in the office of the chief economist, we decided to fill a gap. This originated actually with the first chief economist, where we looked at the descriptive statistics about what these industries were contributing to GDP, employment, and wages. And we found some very compelling results. So descriptively, IP-intensive industries are contributing about 44% of US GDP. Interestingly enough, it's about 44% of total employment. That's not just direct employment, but that's indirect employment through supplier networks. And, workers in IP-intensive industries actually earn more than workers in non-IP-intensive industries. So there's something going on there, right? And I think we can all be happy about that. But as an economist, when I look at these industries, I have to ask myself, okay, well, we see this association between these industries that use IP intensively and these economic outcomes. What is actually happening? And so the association itself is informative, and we've used these kinds of points before in many different documents, but it actually doesn't go and tell us why. It doesn't tell us the role of, let's say, patents in an IP-intensive industry and how those patents translate into economic outcomes. And so to actually understand the role of patents, the best reference that I know of it's a book called The Case for Patents. I hope some of you have seen that. If you haven't, you better, because it is put together by a distinguished professor at Northwestern's Kellogg School of Management. His name is Daniel Spulber, and it was published in 2021. It's really a collection of a lot of his work, but he lays out in a very nice way all the different ways in which patents can facilitate economic activity. So for instance, he of course, agrees with the standard line that patents are an incentive for R&D and discovery. Yes. But he also points out that holding a patent gives you the legal right to determine the pathway between the invention and the actual development and commercialization. Those control rights over that invention are very important. For example, patents, one of their roles is to reduce transactions costs, which allows buyers and sellers to get together to trade patents. If I'm a company and I invent something that's not my core capability, I can now sell it to a company that can develop it. Or these lower transaction costs also facilitate licensing, which is very important for universities in the SCP environment and so forth. I don't want to take up too much time here, but I would like to highlight a couple of things. First, what we have a lot of are statistics and data about activities and processes. We can count the number of applications, we can count the number of granted patents, and we can count the number of office actions that this patent application experienced from its filing to its final disposal. We've got a lot of activity metrics. The problem with activity metrics is they don't connect to the economic outcomes. And so if we just look at activity metrics, the connection, the role in creating the economic outcomes is really fuzzy and opaque. And so one thing that we need to do as a community, if we do indeed want to continue to support patents as one of the mechanisms for increasing economic welfare, growth, so forth, is to not just rely on anecdotal stories, not just rely on our political beliefs or our personal beliefs, but we need to have an open and transparent data system in which scientifically rigorous methodologies are used to connect the activities to the outcomes. And until we have credibility in how we do that, it's going to be easy to poke holes in what patents might contribute to the economy, as we know a lot of people who are naysayers often do. So let me stop me if you need to. I have a couple more things I'd like to say, but I can certainly put it off. So I was looking at the data, and I thought to myself, okay, what do we know about U.S. companies abroad? Well, we can look at the World Intellectual Property Organization data. They have a nice data set there. And what we find is I'm talking now about long run, let's say 10-year trends, because when you look at activity data, like the number of filings, that's really great for kind of getting a sense of where things are going, right? The trends. And so if you look at the US innovators and their patenting outside the US, you find first and foremost that the volume of US patents in foreign offices have been growing over the last 10 years. That's a good sign. That means that US companies are not retreating from foreign markets. In fact, they're engaging with them. So that's a good that's a good statistic, a good trend. Now, if you look at the share of US patents in foreign offices, you'll find that the share of patents by US innovators has dropped dramatically. I think I have some numbers here, but the volume increased by 9% and the share has decreased by 27%. So the share of US innovator patents in foreign offices is now 27% lower than they used to be over the 10-year horizon. Now, that could indicate some trouble, right? So, for instance, it could indicate that we might get crowded out of markets, or some kinds of patent thickets may prevent U.S. companies from entering foreign markets. That's a possibility. I certainly don't have the answer. But one interesting point that was made earlier today was about China. Now, that 27% decrease in the share of US patents in foreign offices actually becomes only 2.8% once you extract China from the overall equation. China is driving that number, and it does speak to the extent to which that's a strategy and for advancing their economic goals. So let me then end on just talking about the US for a second. So that's the WIPO data, right? That's what are US innovators doing abroad. Now, what are US innovators doing here? Well, we can certainly look at the USPTO data for that, and I've looked at it over a number of years under the direction of Deputy Director Stewart and others. What we see is utility patents filed by U.S. residents at the USPTO are in fact increasing at about 3.7% over this 10-year long-term horizon. That's not like a home run hit, but that's an increase, right? But this is actually a bit troubling. If you look at the composition of that group of utility patents, you'll find that the applications on new inventions that do not have a parent application in the system at the USPTO already, that group of patent filings from U.S. innovators, so let me restate, U.S. innovators filing at the USPTO, new inventions without a parent declined dramatically over the 10 years. So why are overall utility patent volumes rising, but the new invention volumes are falling dramatically? And I have a number here. 17% new applications for new inventions have fallen over roughly 10 years. The reason is because there's been a change in the environment. The reason we get a positive 3.7% increase in overall is because continuation applications have exploded. Continuation applications have given us a number that we look at the top line, 3.7, yeah, but if you look at the actual composition, it's alarming, at least to me, to look at that. Now, the final, and I'm ending on this, the final thing that I would say is that what's happening to the proportion of U.S. inventor patents at the USPTO? Well, it's falling. It's been falling dramatically, actually. It was at 56% in 2000, and now it's at 46% by 2024. So why is that happening? Well, it's not happening because the U.S. is innovators are retreating from the office. That's not the explanation. Actually, it's been relatively flat, maybe a couple percent, like I was talking about. That's for utility. But what's happened is there's been a flood of applications from abroad, and that has mechanically dropped the share of U.S. inventor applications at the PTO. And if you look at what countries are actually doing that, you find that 3 countries together account for 90% of the fall in the U.S. share of applications at the USPTO. Any guesses which is the top country? China. The second country is Korea, and the third country is India. Those 3 together account for 90% of the decrease in the U.S. inventor share at our own U.S. Patent and Trademark Office. So I would just say that the data have some interesting things to say, but we need to really have open data and transparent and credible analyses to push ourselves forward.
That is incredibly interesting, Andy, in much, I would say, less rosy picture than we started with, right, for where we are in terms of IP-intensive contributions to our economy. But when you really zoom out and put this in terms of trends over the last 10 years and trends vis-a-vis our global competitors, I think it shows that we have a lot of work to do with respect to our public policies here in this country, as well as our kind of education and awareness building around the importance of innovation to facilitate kind of the taking back of that share and the growth of innovation in this country. So I want to come back to this topic of global competition and some of the dynamics at play with China and some of our other foreign competitors. But before I do that, I want to dig a little bit deeper into some different perspectives within the innovation ecosystem as our approaches to these topics and these patent policy issues are deeply informed from where we stand within the innovation ecosystem. So, kind of digging into the 2 different sectors that we have represented here on the panel, Lori, I'd like to start first with you to talk about how patent protection helped take Qualcomm from a small startup, with a few guys and I think 1 woman in a den, to, now a global computing company. Would love to hear your perspective on that.
Yeah, I'm happy to. And by the way, I'm fascinated by the kind of data that Andy's describing, and we're, as a company that's really rooted in the patent system, we are deeply grateful for the economic analysis that PTO has published over the years. One of the things that we've tried to do to sort of build on that economic story is to talk about how these patent-intensive sectors contribute to the economy in terms of job growth and so forth. And so just to say that I think looking at these issues around the patent system empirically is incredibly important as we talk about the public policy debate that we've been navigating over the last decades now. So Qualcomm, just for folks in the room who don't know, the kind of mission of the company, we were founded in 1985, was to really revolutionize advanced communications, advanced wireless communications. And we have sustained that technology leadership position throughout our 40-year history, which is pretty incredible when you think about it. We self-fund all of our R&D. We invest about 20% of our revenue in R&D, have done that throughout our history. The way we maintain that R&D engine is through the patent system. We patent our technologies, and then we license them broadly to create the ecosystem, just to borrow Walt's term from the first panel, that is able to use that patented technology to create follow-on technologies of various kinds. And really, when you think about how mobile communications, wireless communications has transformed every aspect of our economy, every aspect of our lives, now the kind of underpinning of what will be the AI revolution, you recognize how foundational and fundamentally important these patented technologies are. We are also a leader in mobile semiconductor design, which again has now become the computing power, not just for your handsets, but what we're seeing in the automotive space and IoT, data centers, et cetera. And we've also been very deeply involved in the AI sector. And again, many people, just to go back to Jean's comment, just assume that AI is all about coding, which of course, it is about coding, but it's also about a lot of very intensive R&D. So we've been involved in that R&D sector for about 15 years. So going back to Morgan's question, though, when we were founded in 1985, we were founded by 7 individuals, most of whom were world-leading experts in their fields. And I think it's important to emphasize that because it kind of goes back to the previous conversation about the really critical role that our university sector, our government-funded labs, that kind of basic science, if you will, part of our ecosystem plays in, again, acting as a kind of wellspring or leapfrog for what companies do in terms of taking these scientific discoveries, building upon them to create commercial technologies that, again, sort of revolutionize our lives in various ways. So even though we were that quintessential startup was comprised of engineers and scientists who had decades of experience in the university sector. And last week, I had the privilege of attending the National Inventors Hall of Fame. And the stories that I heard from the inductees, most of who had, again, dedicated their lives to really hard R&D. And then those breakthroughs led to discoveries of one form or another, whether in life sciences or communications or in other sectors that, again, just have made lives so much better in so many different ways. I mean, that's our story as well. And so I think it's always important to understand that the critical role of the patent system is to enable that long horizon, that drumbeat of persistent R&D that can then lead to innovations, discoveries that can be commercialized and then protected throughout that commercialization process, in some cases monetized in order to enable more R&D investment, but without a patent system that, again, is rooted in a system of property rights that allows for these very long horizon R&D investments, which today are increasingly funded through the public sector, or through the private sector rather, you would not have that kind of ability to engage in decades of R&D in order to reach the point where you have commercially viable technology. So that's kind of the story of Qualcomm. We are now a company of over 50,000 individuals, but we are first and foremost an engineering company, and we are first and foremost an R&D engine. And I think what's notable as we talk about the geographic issues and the sort of what has become a kind of geopolitical conversation around technology, when we were that, that sort of quintessential startup, the communications industry was really dominated by Europe. We saw a period where companies like Qualcomm really moved that center of technological gravity to the US. But unquestionably, we are seeing a dynamic where companies in China, in Korea, and other parts of the world are really moving up that R&D ladder. And, all things being equal, where we can succeed through the sort of technological merit of our R&D efforts, that's fine. But I think what's challenging is that as we successively diminish the effectiveness of our patent system, we're seeing other countries work to improve their patent systems. And that is not a sustainable dynamic. So just to say that I'll end on a positive note, I think we are an example of the incredible success that can be built through a strong patent system based on property rights, based on a sound rule of law. But that leadership position is a fragile one, and it's really dependent on the strength of that foundation. And so, again, we're deeply grateful for the work that the USPTO and Congress and DOJ and others are doing to try to rebuild that foundation, but it's a tenuous hold that we have on that technology leadership position.
Almisha, I'd love to bring you into the conversation here to compare and contrast from your perspective the role of patents in the university and tech transfer space, as well as some of the trends that Lori was describing. As Lori was describing the function of the patent system, Lori was noting that it enables R&D over the long term, and that some of the policies that have been in place for the last decade and are now starting to be remedied as throwing up some barriers to industry R&D. But what is it looking like in the university space right now?
Speaking, when you look at the basic research that's done at universities, a lot of it is done because researchers are looking at issues within their communities. They're looking at problems that they can solve, and in finding some of these solutions, then intellectual property comes out of that research. And I think what happens is that when you look at Bayh-Dole, allowing universities to have ownership in these intellectual property allows the university researchers to say, we either going to start a company, have a startup spin out of the company, or we're going to work with industry. So universities tend to work more with industry. We don't operate anything other than the IP itself, but then working with the industry to partner to get these products to market. And so commercialization becomes important at the university end to make sure that these products end up reaching the hands of the people that needs it the most, whether it's a drug delivery, whether it's tools or resources that are going to help impact our society, because what university is doing is basically for societal impact. That's the whole goal of why universities engage in R&D and engage in IP protection to ensure that the people who need it the most receive it. So I think in looking at the contrast, we're looking at how do we partner with a Qualcomm, how do we partner with other industries to make sure that these technologies that are coming out of the university are actually reaching the people, are developed to reach the people that needs them the most. I also think that one, for the university and specifically for the researchers is we'll incentivize them to continue doing the great research that they're doing. They're seeing the good that is coming out of their work and they want to impact society. I think it also helps universities to figure out how can we have some return on investment for what we're doing to ensure we're growing more research. We're also creating jobs in our community. We're also helping our students move forward with the research they're doing and to create jobs for them as well. I think when you look at, I clapped earlier for the Bayh-Dole because it has been working. It's one of the strongest pieces of legislation that we have around IP rights. It has been working. There's no need to change it, right? Because it's working not only for the university, but it is working for the partners that the university has with industry. So I'll continue to champion the Bayh-Dole along with other university partners and others to make sure that we have such a strong legislation that help us move our technologies forward in conjunction with industry partners such as Qualcomm and
Lori was describing earlier some of the challenges that industry is facing, vis-a-vis our global competitors. Given the importance of industry partnerships in that university commercialization space, are you feeling that? Is that sort of pressure and those challenges filtering down to the university level conversations?
I think we're seeing some of those challenges. It may be different to how industry is seeing it, but for us, it's a conversation about the speed and how we move in working out the agreements with our industry partners to ensure that we're moving at a speed that is competitive, and so we're not left behind. So in those conversations, we're working with groups like UIDP to ensure that the industry partners are telling universities exactly what some of the challenges they're having so that we can meet them where they are and ensure that we're doing proper collaboration across the whole ecosystem to ensure that we're protecting the IP at the rate that it needs to be protected.
Sticking with this topic of global competitiveness, Brendan, I'd love to bring you into the conversation. I know you're here speaking on your own behalf as an individual today, but I'm curious about your thoughts on Andy's statements about some of what the data is saying, and maybe we'll start there.
Great. No, that's very helpful, and thank you for having me. It's great to be here from the State Department. So greetings from Secretary Rubio and everyone there, and it's great to see Andy again. We worked together when I was a chief of staff at the USPTO with Director Iancu, so we always ran to his office for good stats to make us look good. Yeah, so in terms of global competitiveness, I think at the State Department we play kind of the soft power role there, and so I think USTR is a little bit more of the hard power with the tariffs and various kind of trade restrictions, as well as the Department of Commerce. So I would say the key, I think, in global competitiveness and patents is leverage, and I guess it's leverage to make foreign countries kind of change their laws or change their practices, when they are addressing U.S. companies in their courts and administrative processes. So, one instance, I've helped with the USMCA there, and so we were able to get in the IP chapter just some provisions related to transparency. And so all the decisions in Mexico, part of that agreement was that they would publish them so that our companies could know why, was this decision made, and make the system, I think, as Director Iancu and Director Squires have said, more predictable and reliable for our companies operating in Mexico. So I think in terms of global competitiveness, I think tariffs, certainly that hard power tool does help to some extent in that negotiation. And I think you're seeing that with the renegotiation of USMCA ongoing. And I think Ambassador Greer was just in Mexico and, is going, I think the tariffs are still in play is kind of what I've gathered from those discussions. I'm not directly involved in them, but I would say, having means to force behavior changes on other countries, I think is helpful there. So, yeah.
So in terms of levers and tools to influence the treatment of patent rights in other countries, how do current U.S. patent laws and practices fit into that? Because you talked about, hard power, soft power. What about passive power?
Yeah, no, that's a great question. I think, when I was at the PTO, and I think Andy may have been involved in some of these discussions, there was a lot of discussions of harmonization, and I think that's taking all the laws and harmonizing them. So there's kind of one kind of global system of legal norms that all the businesses can work towards. And I think that was good for a number of reasons, but I think in terms of American companies having, because we have such a strong kind of property rights-based system here in the United States in the Constitution, having, more of our laws influence, I think, foreign laws is just absolutely important in that discussion, because I think the system here that we've set up has created great companies like Qualcomm and supported inventors. And I'll just put a plug in. There's a really great book that when I was at the PTO, I read by David McCullough called The Wright Brothers. And it's fascinating to show the interplay between, they obviously they're from Ohio, invented here in the United States, but then there's a whole section of the book devoted to their experience in Europe and the different processes they went through to prove their technology and get patents there. So we live in a global economy, and I think, using our laws as a model for the rest of the world, I think is helpful to show our leadership there. So, yeah.
Go ahead. Can I build on what Brenda was saying? Yeah. I mean, when I started my career in intellectual property many, many years ago, it was almost taken as a given that the US was the gold standard in intellectual property. And it was almost taken as a given that the US would kind of use that platform to not only ensure that it's strong, our laws were, incredibly strong, but that we were actively encouraging other countries to meet our standard of intellectual property through bilateral trade agreements, through multilateral trade agreements. And I think that's a mission that has eroded over the years for a variety of reasons. But one of the things I was really thrilled about was in the most recent Special 301 report that just came out. For the first time, we now have, and for folks who don't know, the 301 report is an annual report. It's an interagency document led by USTR, but it includes input from the Department of State, our FTC, DOJ, USPTO, among others. And it really lays out, the areas of priority in the intellectual property space for the US government, and then details areas where different countries need to, address different intellectual property deficiencies. And for the first time, that report now emphasizes the critical importance of patent rights and patents and standard essential technologies. And I think that sends an incredibly important message and signal to the rest of the world that these are priority issues for the US government. And I will just say anecdotally, I mean, again, just to build on your question and Brendan's comments, for a company like Qualcomm, where we have not only sort of a global technological footprint, but where we are contributing our patented technologies to a global communication standard, it's not enough for the US to have a strong system of intellectual property rights. We have to have that stability, that strength in reliability in our patent rights globally. And without that, the entire sort of value proposition, if you will, of R&D leadership starts to fall apart. So just to add to Brendan's comments that, we can't look at these issues solely through the prism of what are we doing in the United States. I mean, that is table stakes, right? Yep. We have to be a leader in intellectual property to insist that others follow suit, but we have to be looking at these issues through that global lens. And so, the role that the State Department, PTO, and other, parts of that interagency are doing to ensure that global perspective, I think is important and essential.
Lori, I'm so glad you chimed in and highlighted the Special 301 report, because that was exactly where I was heading next.
I should have known. Yeah.
No, and so thank you for highlighting the fact that the Special 301 report sent a really strong message to our global competitors and frankly, US stakeholders as well about the importance of strong patent rights here and abroad. And I also wanted to call out 3 trends that the report highlighted that are emerging in our global competitors and harming US innovation. The first being court rulings called anti-suit injunctions that bar U.S. companies from enforcing their patents anywhere else in the world. The second, judicial or administrative procedures that compel innovators to grant, without their consent, global licenses to patented technologies on terms set by the court or the government. So Lori, I'll come back to you on that one. And then number 3, judicial or legislative efforts to restrict the availability of injunctions against patent infringement, which is the core remedy that patent holders use to enforce their rights. So Brendan, given states' role, in contributing to this report, I'd love you to hear your perspective on how these 3 trends in particular harm U.S. innovation and competitiveness, and why this administration was concerned enough about them to include them in the Special 301 report this year.
Great. Yeah, so there are 24 to 30 bureaus, depending how you count them, at the State Department. And so one of them is the Economics Bureau, and that's the bureau that provided kind of comments on the Special 301 report. And yeah, I thought it turned out very, very well. And, the 3, issues, I think, for our companies abroad, as you mentioned, are kind of the anti-suit injunctions and kind of how foreign courts have created overbroad injunctions in various cases. And I won't kind of harp on the injunction as a remedy issue, because I think we talked about, or the previous panel talked about it. And then the other big issue is court setting licensing rates. So I think just, the first step, I think, as Lori mentioned, is naming the issue. And, obviously we have a lot of sensitive negotiations going on with some of the countries, and I think some of them, might apply to more countries, or a country more than other countries, and I won't name them, but the president is meeting with the president of one of the countries later this week. So, so I don't want to get ahead of those discussions. But I will say we're very interested in these issues. We think they do impact our global competitive position. Licensing rates. We're in a market economy here in the United States for the most part, and we think obviously when you enter into non-market economies, courts favor their own companies, and at the State Department, in the Economics Bureau, we do engage, economic diplomacy, and will engage courts and decision makers in countries, all the time through our ambassadors. And I'll give a plug for the USPTO Attaché program. I think it's a great kind of resource for businesses to make their issues known. And if you're in those countries that we have them, I know that they can be very helpful, solve the issues. Yeah. So.
Lori, coming back to you on those specific trends, as Brendan said, we've talked a lot about injunctions today, but I would love if you could share some of your thoughts on the first 2 trends. So first, the advent of anti-suit injunctions, which are throwing up a barrier to the enforcement of patent rights, as well as global rate setting.
Sure. Yeah, I think when you distill some of these trends, it's fundamentally an attack against access to injunctive relief, access to market-based valuation, and then candidly, it's an effort to assert extraterritorial jurisdiction over what are often global patent portfolios. So really negating the role of U.S. courts to determine critical issues like remedies in the context of a patent right. And that kind of 3-line attack is pretty much the death knell, if you will, to the ability of a patent to kind of serve its purpose. So these are, I think, the trends that the report lays out are really the, I don't want to be overly dramatic here, but they're kind of the existential issues that that patent owners, especially companies with global patent portfolios are facing in various jurisdictions around the world. So in the context of the attack on valuation, for companies like ours, we are dependent on the ability of our ability to achieve a fair return on investment and to achieve a market-based valuation of our patented technology. And that valuation process historically has occurred through bilateral licensing negotiations. So we sit down on one side of the table and the user of our technology sits on the other, and we negotiate what we consider to be a fair price for that technology. And so again, if you look at companies like ours who actually license our patents, and again, if you participate in a global standard, you are required to license your patent on our portfolio on a what's called a fair, reasonable, and non-discriminatory basis. It's that ability to rely on market-based valuation that becomes, again, the kind of value proposition that sustains your ability to continue to make these R&D investments on the strength of your patent rights. And so what we've seen in various jurisdictions is an effort to kind of undermine the sort of primacy of that market-based process, either in favor of a court-dictated valuation or a government-dictated valuation. And we're seeing that kind of line of attack, if you will, in jurisdictions like Europe, candidly, where you would think that our interests would be aligned in terms of wanting to preserve that market-based system of valuation. But again, when you layer on top the fact that you can no longer potentially rely on the market and comparable licenses to determine the value of your technology, not just in a particular jurisdiction with respect to the patents issued by that jurisdiction, but instead there's an effort to extend that top-down valuation to your patents globally, then we as a nation, organizations based, in this country that have relied on the U.S. patent system, it's a huge blow, if you will, to our system of property rights. So that is we are seeing that pattern of activity across multiple jurisdictions. And again, when you combine that threat against valuation with an inability to obtain an injunction. And again, you're seeing an extraterritorial effort through anti-suit injunctions to not just preclude injunctive relief in a particular jurisdiction, but globally, in some cases backed by penalties. If you do attempt to seek an injunction in another jurisdiction, that is really an effort to, whether intentionally or unintentionally, but the net effect is to negate the role of the U.S. patent system in, creating an enforceable property right.
And you talked earlier about the role of this report in sending a strong message, right? And making clear what the norms and expectations are and should be around intellectual property enforcement. But what else should Congress and the administration do to address these concerns?
In terms of other countries or just in
both
terms of
here and abroad?
Look, I think in terms of the role of Congress, the most important job was stated on the first panel. It is really righting the ship, if you will, in terms of fair access to injunctive relief, a fair PTAB process. And again, the injunctive relief issue is addressed through Restore. The PTAB process is addressed through Prevail. And we're deeply grateful for the work that PTO is doing in the interim to try to achieve some of those sort of due process type equities. And then 101 eligibility. And I won't, go into why each of those kind of cornerstones of the patent system are critical. But from my point of view, that is job number 1, 2, 3 for Congress. But going back to Brendan's comments and my comments about 301, it has to be a whole of government effort and a whole of government commitment to the strength of our patent system, not just in the United States, but globally.
And Brendan, how would you describe what you're seeing in your current position, as well as, given your connections to PTO and some of the other parts of government that are important to Lori's point about a whole of government approach here?
Yeah, no, it definitely is full of government. And so we work the diplomacy aspect, talking with foreign governments all the time. I was just in Brasilia, discussing some business issues with the about 6 countries, and attended a hearing of the Inter-American Court of Human Rights there. And so I think a lot of the time it's just having the United States in the room to maybe stop something bad from happening, or, representing the U.S. position. So, across government, I think USTR did a great job on the report. I will say, Vietnam was added this year, and I think you saw a lot of the production shift from China because of the 301 tariffs into Vietnam. And so there's just a lot of, I think, copyright holders that are, having issues there and brands as well. And so I think, I think they have 30 days because they were just elevated on the list. So they have 30, the USPR has 30 days to decide on whether they're going to do an actual 301 investigation there. And so that would bring tariffs into play. And so I think there is, a whole of government approach. It's kind of name the problem and make everyone aware about it. And then if we have to increase the pressure economically to try to help our companies out. So.
I'm going to open it up for questions in about a minute. So get your thinking caps on and get ready to answer some questions. But before I do that, Brendan, you are in the unique position perhaps of having served in both the first and now the second Trump administrations and having served in various roles. So how would you compare and contrast the approach of Trump 1 and 2 thus far on patent rights?
Great. No, great question. I see a bunch of PTO executives there, so I won't badmouth them publicly. No, I think they're doing an excellent job. With Director Iancu, we were able to kind of, I think, get the ball rolling in the right direction with some PTAB reforms, changing the claim construction standard to match the district court. And I think they've, continued those reforms to support inventors and American innovation. I think, the PTAB, you've obviously seen a lot of shift into kind of re-exam out of the PTAB. And so I think certainly, I guess General Counsel Matich is down in Texas now arguing for some more injunctive relief for companies. And so I think you're continuing to see the pro-innovation, pro-IP policies pushed from the PTO, just like we did in the first term. So, yeah.
All right, we'll open it up for questions. Yes, Mike. And I'll ask everyone to please, even if we know you, to say your first and last name and your affiliation.
Absolutely. Mike Waring with Autumn, great panel. Almisha, I wanted to ask you a question. I know that you spoke quite eloquently about the Bayh-Dole Act and the importance that it's brought. But we're also starting to see a lot more activity at the government level that kind of tries to go around Bayh-Dole through what's called other transactional authorities. We're seeing that all the time. Maybe it started with the DOE deck, but now we're seeing it in contracts that universities are being asked to sign that relate to research and perhaps sharing money on the back end and all kinds of other kinds of things. Can you speak to how those kinds of evasions of Bayh-Dole's intent are having an impact on a college campus like Jackson State?
That's a very good question, Mike. And yes, I just dealt with an OTA like 2 weeks ago. And one of the things that's happened when you go around Bayh-Dole, again, I'm a strong advocate for Bayh-Dole, and I told you why earlier, because Bayh-Dole has really helped universities move inventions forward. So we're no longer just publishing the work that we're doing, but we are creating inventions that we're putting out there for companies to take and manufacture and get products into the market for public good. When you have those go around, what it does is put a burden on the institutions, right? Because now we have to get into the business of doing things that we were not designed to do as a university. It's also creating challenges in how we work with our faculty, how we explain these processes and the changes that we have to do. And oftentimes you would hear researchers saying, I am doing this for public good. I'm doing this because I want to see societal impact. But when you have those challenges that are coming in, you're trying to explain why we have to go in another route and share, give this up, then it becomes a problem where they're like, well, why are we doing this in the first place? Why should we do this? Maybe we should go back to just publishing our work and, finishing our work with it. But as you can tell, you can see a lot of the inventions that are out there in the public came out of universities, right? And they're doing a great job of the research that's happening. And so we have to be able to make sure that Bayh-Dole stays strong, that we're not doing any workarounds, so that the university can do the work that they intended to do when it comes to the R&D. And I think that we have young people in our ecosystems that are trying to get startups. They're trying to go out and do great work. And so it's important that we support them in however we can. And I think that's why it's important to continue supporting Bayh-Dole. Those OTAs and other mechanisms, again, are challenging. They're creating, new learning for us in the space, and new ways to say, how do we do this? Are we being, as university, being strong-armed into do something that we didn't want to do in the first place, or that was not created when we started out? And put in, even now, putting in some of those in the agreements that we're working on, again, create a backlog at the universities to look at those in a different way than we look at them in the past. And whatever we can do, and all the people who are here working from the governmental agencies, I hope you will understand the impact that those are having on universities, and how Bayh-Dole is one of the strongest ways, is one of the piece of legislation that has stand the test of time and has really been working for American innovation. And I want us to continue supporting that.
Other questions? Bill Wichterman.
Bill Wichterman, I'm here at Covington. A question for Brendan McComas. Brendan, thank you for coming today. If you could speak to the importance of national security, and we've been talking a lot about economic competitiveness, but to what extent does the State Department, knowing that you're here speaking on your own, but thinking about not just international competitiveness, but how do we stay ahead on the national security front vis-a-vis innovation?
Yeah, that's a great question. And I know Secretary Rubio is also the National Security Advisor, so he's keenly aware of all the kind of overlap there. But and a lot of the time, I think his talking point is economic security is national security. And so if we're want to increase innovation here, that's going to lead to our own security, in the military space. It's important, I think, first off, that we have protections in the United States, and also that we're, with our allies and partners, we're able to ship and protect our innovation to allies that are in kind of war zones. Obviously, we have, Israel is going through a lot right now, and Russia and Ukraine, there's a lot going on there. So I think, in our diplomacy, I think just respecting intellectual property of all the companies that are involved in that, I see that kind of every day. And, at the State Department, we grant licenses when we're shipping weapons abroad. And so there's a lot of terms in these licenses to respect intellectual property. So I think that's kind of one area I see it in. But, Secretary Rubio always says, we're doing everything to make America stronger, safer, and more prosperous. And so I think that plays into every interaction we have around the globe, all our embassies, and all the international conflicts kind of ongoing. So I think respecting property rights is just in our DNA. And so, emphasizing that to partners and allies. Sure.
And Andy, do you have a perspective on that question too, given what you were sharing about the data trends and some of our foreign competitors that are overtaking our shares?
In terms of national security? Well, yeah, I think that's a little bit harder a question for an economist, but, I think it goes back a little bit to what Walt was saying. He was saying that, there are a lot of other countries that are kind of getting free information, and we're teaching the other countries our technologies. But that brings, brought to my mind in terms of the national security question was we've got the grand bargain, right? So we're going to get a patent, but we're also going to disclose the technology. So, in terms of national security, I'm not sure how we can get rid of half of the grand bargain and keep it secret. So I don't have any great insights on that particular thing, but
thank you for pulling out that point though about IP theft, because Brendan, I know this is something that you guys have been very focused on too. So is there anything else you'd like to add on that?
No, and I think that's exactly right. Yeah, obviously the 301 investigation we did found a lot of IP theft, on behalf of China. And so that's why we had tariffs in various sectors. The other tool we have in our toolkit is export restrictions. And I think the Department of Commerce has done, a number of restrictive actions in the national security space. And so we work with them and, a number of companies, chip companies, and the AI space in particular. So I think that's another tool we have to stop folks from stealing our technology. Yeah.
One other quick thought in terms of my insecurities about national security is about AI, right? So we talked about the 101 issues, but there's also 112 issues. How are you going to disclose when you've got these black box, machine learning models or LLMs? So it's, in some sense, it's good because we won't be telling the others how it all works because it'll be in a black box. But for our U.S. innovators, right, I think we have an issue with AI, not only in terms of one-on-one, but also disclosure and how do you teach someone skilled in the art to make and use from a patent document? That's an interesting thing with an AI.
Lori, please.
Yeah, just one other thought. Can you hear me? Okay. What we always say is that research and development is the first link in the national security continuum or chain, however you want to, whatever your preferred metaphor. And so, we live in a time where technology is really front and center in our conversations about economic security, national security. And to Bill's point, these are really intrinsically linked concepts now. So ensuring that R&D is taking place to the extent possible in the United States, I think is a critical dimension of national security, and the patent system is what enables that. It's what allows, whether we're talking about universities or government or private companies, to maintain that R&D activity, but ensuring that it's taking place at home.
Thank you. We'll take one more question. Megan?
Yeah, so extending Lori's point on R&D, I'm curious, what kind of data could we use to better tell the story that research and development is worth the investment, especially investment from the federal government? And then taking it the next step, how patents can also be part of that economic data story.
I mean, I have a quick answer to that. So there have been many moments in which I was trying to present a point of view to a policymaker, and it actually what you need is you need a variety of different pieces of evidence, right? You need the story about how it's affecting somebody's life. You need the economic analysis that says that it's very important, and it can't just be typically a descriptive analysis. Sometimes that works, but then they'll break it down pretty quickly. So you really need this broad perspective, a package, if you will, to take forward to be able to convince people on those issues.
Can I just add one other point? I talked about the fact that Qualcomm's founders, spent many years in academia before starting a new company. And again, that's the story of so much of our entrepreneurial R&D intensive economy. But I think it's also important to just keep in mind that, and this is maybe more of a qualitative comment than a quantitative comment, but for companies like Qualcomm, we're a publicly traded company. We're accountable to our investors. Even though we are able to invest in long horizon R&D, it's the fact that we have a university system and a R&D intensive government system of labs and so forth that really allows that sort of decades long dimension of our R&D ecosystem to evolve, where they can spend years and years and years solving the most complex problems in a world and really pushing the boundaries of math and science forward. Sometimes privately or publicly traded companies don't have that luxury because of the fact that, again, we are accountable to our investor community. So just to say that I think as we think about the role of different dimensions of our R&D economy, it's the fact that we have a part of that economy that's sort of less driven by accountable to, short-term profit demands or short-term return on investment demands. And I just think that's a critically important dimension of how we should be thinking about this R&D equation.
Thank you. And I'm looking forward to speaking with many of you later this evening at the reception, and I'll be curious to hear your takeaways from this conversation. But if I could just leave with a closing thought, coming back to our panel title, How Patents Make America Stronger, my takeaway from this discussion is that patents certainly can and do make America stronger, but to realize the full potential of our patent system for another 250 years of progress, we have a lot of work to do, both here and abroad, right? To refine and preserve our own patent system, to continue the work that the USPTO is already doing, as well as other parts of this administration, to work with Congress to right the ship, as Lori said, and to ensure fair treatment for U.S. inventors that are doing business abroad. So thank you to our panel.